Well, then, we're back again already. I thought we'd have at least one day of a break from Delete Lawz. I mean, I didn't think it would be more than a day because I did expect Google to file by tomorrow, but they filed a day early, and we have action in Vegas again. And this is getting ridiculous. I have a feeling that Delete Lawz is probably feeling overworked and stressed because he's juggling an awful lot of lawsuits right now, and he's not very good at them. And I have a feeling that it's gonna have consequences. So, and I think the first of those consequences, of course, is that a not Delete Lawz lawsuit, but also kind of a Delete Lawz lawsuit. I have a feeling that the Floyd Wallace suit is going to fall by the wayside because Delete Lawz won't have time to be engaging in the unauthorized practice of law on others' lawsuits. And they still haven't served anyone on that one yet. So that, that's basically the update on there. But like I said, we have both Las Vegas. We have Las Vegas, and we have an update from Google in the Boston suit. So uh, let's go to Vegas first, since it's closest to me, and it's also the one I have pulled up. So looking at the docket once again, DeCastro versus Las Vegas Metropolitan Police Department. Scroll down, and the docket got a little out of order, annoyingly. And all of these are from the 13th, even though docket number 21 is from the 12th, and then 20 is from the 13th. But 24 and 23, out of order, both showed up on the 14th, even though they're dated the 13th here, although the clerk entered them on the 14th here. So that's a little annoying to my brain to figure out, but that's what we're looking at. So, what is it that we are looking at out of order? Well, first, we have like I said, it's out of order. So 23 here, we have another filing from Mr. Jensen. Motion for leave to file suggestions in opposition to defendant's motion to dismiss. And I've read it. I don't know what that is. It's not something that exists in law. I mean, we remember from the Darrell Brooks trial. Is that lawful law? This isn't. Um, and then number 24, we have an order already from this time the magistrate judge, Elena Ucha, however you pronounce her name, uh, on Jensen's motion for joinder, plaintiff's motion to stay, and motion for extraordinary writ of mandamus. And it's denied. Surprise, surprise. And I'm just as amused as I am by all this. So, Mr. Jensen left a couple comments on yesterday's video, and his primary comment, he said, read the case law. And so here's some general life advice for Mr. Jensen. When you are the one who is making extraordinary claims, you need to provide the evidence. You can't say, no, you're wrong, I'm right, go find my argument for me. That's not how it works. If you think there is case law supporting your argument, you're the one that needs to provide it. And that's not just in the court of law, that's any debate. You need to provide the evidence to back up your assertions. That's all. So with that, let's jump into the documents. And the first one is from Jensen, as I mentioned, and he's still demanding jury trial demanded by right and privilege. Even though he doesn't have a right or a privilege to anything in this, but that's beside the point. So Jensen's motion for leave to file suggestions in opposition to defendant's motion to dismiss comes now. I still laugh every time I see comes now. Intervenor applicant Jason A. Jensen seeks motion for leave. I think that should be seeks leave to file a motion, but seeks motion for leave to file suggestions in opposition to defendants LVMPD and the officers' motion for partial dismissal and defendant Tory's joinder to motion for partial dismissal under local rule 7.2G. Wherefore, Jensen prays this court to allow Jensen to file the suggestions in opposition to the defendants attached to this motion, or to their motion for partial dismissal attached to this motion. Jensen prays for all relief just and proper, sincerely and respectfully submitted, signed Jason A. Jensen. And yeah, that's it. That's the entire thing. I don't get it. I really don't get it. He's not a lawyer, that as far as I know. He hasn't made an appearance for a party in the case, so his suggestions are meaningless. Why he thinks the court needs to see his suggestions is beyond me. But it's all irrelevant because, as I mentioned, the court has already ordered and denied his motion to intervene. So let's take a look at that. And it's order. Pending before the court is Jensen's motion for joinder, plaintiff's motion to stay, and motion for extraordinary writ of mandamus. The opening paragraph of this filing shows that Jason A. Jensen, who is not a named party in this action, styles himself as an intervenor plaintiff under Rule 20 of the Federal Rules of Civil Procedure. Mr. Jensen seeks, among other things, a stay of a criminal case apparently pending in Las Vegas Justice Court. Mr. Jensen's motion for joinder fails for a number of reasons. First, the motion seeks federal judicial intervention in a pending state criminal proceeding. The Younger abstention doctrine prohibits federal courts from enjoining pending state court criminal proceedings, even when there is an allegation of a constitutional violation, unless there is an extraordinary circumstance creating a threat of irreparable injury, citing Younger versus Harris. The Supreme Court instructs that federal court abstention is required when there is a parallel pending state criminal proceeding, citing Sprint Communications versus Jacobs from the Supreme Court in 2013. Mr. Jensen identifies no extraordinary circumstances warranting federal court intervention in the pending state court proceeding. Second, Mr. Jensen, a non-party to the dispute filed in this court, cannot intervene in this case unless he can establish an interest in the events that are the subject matter of the underlying action. Remember when I said that exact same thing, how the case I used as an example was Hollingsworth versus Perry, the gay marriage case from California, where Hollingsworth intervened and the Supreme Court denied the case because Hollingsworth couldn't establish an interest in the events of the subject matter. He couldn't show that he would be injured if other people could get married. So I showed, well, I explained that this exact thing, he can't intervene in the case unless he can establish an interest in the events that are the subject matter of the underlying action. And so another example I've mentioned before in relation to Google and copyrights, and it completely slipped my mind yesterday, but the Acerthorn lawsuit that was decided last year, basically Acerthorn is a YouTuber and he accidentally live streamed, basically, and it's just like him psyching himself up or something in the background and background noises. But people restreamed it to make fun of him and he sued, but he also said my streaming software started on its own. So the court said, well, then it's not copyrightable because it had no human involvement in its creation. So it doesn't qualify for a copyright. But he sued a bunch of people and he sued Google, but then he dismissed Google because they were going to defend it and tried to get default judgments against small creators. So YouTube intervened because they said, hey, we have a great interest in this case because if people are abusing the copyright system on YouTube, that affects YouTube. So they were allowed to intervene and they won. So that's an example of where intervening works. So Mr. Jensen fails to establish any basis to intervene under Rule 24. My computer isn't wanting to cooperate today. But Mr. Jensen fails to establish any basis to intervene under Rule 24. Further, Rule 20 of the Federal Rules of Civil Procedure provide Mr. Jensen no intervention rights under the circumstances presented. Third, and finally, a writ of mandamus is an extraordinary remedy limited to extraordinary causes, citing Burlington Northern Santa Fe Railroad versus U.S. District Court from the Ninth Circuit in 2005, which quotes Cheney versus U.S. District Court from the Supreme Court in 2004. When evaluating mandamus petitions, courts are guided by what is known as the Bauman factors, which when I read this earlier today, I read as the Batman factors, which frankly I would prefer Batman factors, but we'll stick with the Bauman factors, which include: one, whether the petitioner has no other means, such as a direct appeal, to obtain the desired relief; two, whether the petitioner will be damaged or prejudiced in any way not correctable on appeal; three, whether the district court's order is clearly erroneous as a matter of law; four, whether the district court's order is an oft repeated error or manifests a persistent disregard of the federal rules; and five, whether the district court's order raises new and important problems or issues of first impression. Oh, wow. Wow. I didn't see this earlier. What's the case they're citing? Perry versus Schwarzenegger from the Ninth Circuit in 2010. Now, why am I excited that they're citing Perry versus Schwarzenegger? Because Perry versus Schwarzenegger later became Perry versus Brown, but at the Supreme Court, it was Hollingsworth versus Perry, the exact case I cited. Wouldn't you know? And Perry versus Schwarzenegger cited the Batman factors because Bauman versus U.S. District Court is a Ninth Circuit case from 1977. Mr. Jensen fails to address any of these factors in his filing. Further, the court has a little snark here that I appreciate. What is decipherable in Mr. Jensen's motion presents nothing warranting the court's intervention in the state court proceedings apparently underlying Mr. Jensen's filing. The court found him indecipherable as well. Accordingly, it is hereby ordered that Jensen's motion for joinder, plaintiff's motion to stay, and motion for extraordinary writ of mandamus is denied. Dated this 13th day of June, 2023, signed by Elena Ucha, United States Magistrate Judge. Now, that order was fairly short and sweet, but I liked it. Especially since it quoted the same case as I did, but it was good. So let's hop on a plane across the country now to the district court for the District of Massachusetts. And DeCastro versus Abrams. Now, I haven't read this motion yet, so this is my first impression of it. But scrolling down, you'll recall we left it on June 5th with Judge Burroughs granting Google's request for leave to file a reply to Delete Lawz' opposition to Google's motion to dismiss or transfer. I mean, I'm going to call it a motion to dismiss because that's what they really want, even though they put motion to transfer first. But so this is their reply, and I'm going to go out on a limb and say, expect within the next couple of days an emergency motion from Delete Lawz trying to get a SIR reply, which I doubt will be allowed, but he's going to ask for it, and it's going to be whiny, and it's going to be awful, but it's going to be histrionic. But Sir replies are rare, in case the video cut out when I said it the first time. So let's jump straight over to the motion. If it wants to click over, of course. Ugh. I thought I maximized that first. So remember, it said in the case caption, you need to say leave to file granted on June 5th, which they did right there. And so this is Defendant Google LLC's reply in further support of its motion to transfer to the Northern District of California, or in the alternative, to dismiss. And we have the table of contents. 1. Plaintiff cannot avoid transfer by ignoring Atlantic Marine. 2. Plaintiff cannot prevent dismissal by registering one work after filing suit. 3. Plaintiff granted YouTube a broad license covering all works in suit. And 4. Conclusion. That's an exciting table of contents. Table of authorities looks similar, if somewhat condensed, or even maybe not condensed from last time, but I don't know that they had this Roblox versus Wowie group last time, but that's quite a name. Wowie. And finally, on page 5, we have the first page of the motion. By leave of court, Google LLC submits this reply in further support of its motion to transfer or dismissal, for transfer or dismissal, to address arguments raised in plaintiff's opposition brief. Remember, the reply brief, you don't get to raise new arguments. It's to reply to new arguments raised in the opposition brief. So Delete Lawz, when he said in his opposition to them even being able to file a reply brief, well, if they file a reply brief, I'm going to need a Sir reply. But they're not raising new arguments. They're limited to just responding to his new arguments. So 1. Plaintiff cannot avoid transfer by ignoring Atlantic Marine. Plaintiff seeks to avoid transfer by simply ignoring the controlling framework set out in Atlantic Marine Construction Co. versus United States District Court for the Western District of Texas from the Supreme Court in 2013. Transfer should nonetheless be granted. The parties agree that YouTube's terms of service constitute an agreement between YouTube and plaintiff that all claims arising out of or relating to these terms or the service will be litigated exclusively in the federal or state courts of Santa Clara County, California. Plaintiff does not dispute that. In addition to expressly accepting the terms of service when creating his YouTube channel on July 28, 2020, he agreed to the same forum selection clause again when he agreed to the YouTube Partner Program terms, which allow him to earn ad revenue from YouTube's service. Plaintiff nonetheless makes 2 arguments against transfer, both of which fail. First, plaintiff argues that his claims against Google fall outside the scope of the forum selection clause because they are not claims between users of the service and YouTube related. So they are not claims between users of the service and YouTube related to the products and services that YouTube provides the users. To the extent that argument is comprehensible, it is wrong. Wow. Both Benjamin Margot and Magistrate Judge Utah saying, hey, these arguments are incomprehensible. Plaintiff concedes that his claims are related to YouTube's alleged failure to take appropriate action for copyright infringement on its platform. More specifically, he alleges that Google is liable for YouTube users copying videos onto YouTube that he had previously uploaded to YouTube, e.g., supplemental complaint, paragraphs 9 through 12. Such claims obviously arise out of or relate to the YouTube service and are indistinguishable from other copyright claims that were found to be covered by YouTube's forum selection clause, e.g., Keifel versus YouTube from the Northern District of Georgia in 2021. Plaintiff makes no effort to distinguish the cases that broadly interpret YouTube's forum selection clause to cover such claims. Second, invents a new legal standard that directly contradicts Atlantic Marine. Delete Lawz is, he always thinks he's in control. He gets to state what the law is. He gets to state what the facts are. Captain Conclusory, if he says it, it goes. And here he invented a new legal standard directly contradicting the standard laid out in a Supreme Court case. He wrongly asserts that forum selection clauses can only be invoked by a necessary party. They do not apply if they would cause unanticipated inconvenience, and the burden is on the party seeking to enforce the clause. None of that is true, and plaintiff makes no attempt to distinguish the ample case law Google cites to the contrary. Footnote 1. In any event, plaintiff's cases, Delete Lawz cases that he cited, uniformly support the enforcement of similar forum selection clauses. See Brayman versus Zapata Offshore, Nebraska Theater Corp versus Eddie Ely Landau, or New England Theater Court, Northeastern Theater Court. I don't know. I hate abbreviations. BABN Tech. This is why I don't even bother looking up cases that he cites, because if they exist, he almost uniformly gets them wrong. He is terrible at interpreting case law. Sometimes it can be difficult. I'll admit that. Some judges love hiding the ball, but to uniformly get it wrong, that's pathetic. Second argument: plaintiff cannot prevent dismissal by registering one work after filing suit, with after italicized. To survive a motion to dismiss, a copyright plaintiff must register the alleged infringed works before filing suit, in bold italics, before filing suit, citing Foss versus Marvick Inc., First Circuit 2021. Emphasis added. So let's repeat that, especially since the citation's in the middle of the sentence. To survive a motion to dismiss, a copyright plaintiff must register the allegedly infringed works before filing suit, allege that registration had been obtained prior to suit, citing Cortez Ramos, which has been cited before, and plausibly alleged that the copying of the copyrighted material was so extensive that it rendered the infringing and copyrighted works substantially similar, citing Kenny v. Warner Brothers Entertainment from the District of Massachusetts, which itself quotes Johnson v. Gordon from the First Circuit. So, the second part, you have to allege that the registration was obtained prior to the suit. That's not done in any of his complaints, not in the amended complaint where he switched it to copyright, not in the first supplemental complaint, not in the second supplemental complaint. The first he ever mentioned the existence of a registration was in his opposition to the motion to dismiss. It's not alleged. It does not save this suit. Plaintiff's complaints do none of these things and fall far short of basic pleading standards. See Ashcroft v. Iqbal. Remember, we've talked about Ashcroft versus Iqbal many times, and its predecessor case, which is still good law. It's just Iqbal narrows it down further. But the I didn't say the name of the still good law, but predecessor case, Twombly. Remember, under Iqbal and Twombly, or the Twickball standards, in order to survive a motion to dismiss, you have to plead more than threadbare conclusory restatements of the cause of action, basically. Meaning you have to plead sufficient facts that on its face, if taken as true, those facts can support your case. They can support the cause of action. If you haven't pled sufficient facts to support that cause of action, it must be dismissed. So, and remember, let's jump back to Vegas for a minute. Delete Lawz is trying to he's trying to claim that basically because in LVMPD's motion to dismiss, they didn't move to dismiss a couple of the causes of action, namely the unlawful use of force and I think unlawful detention. But all the civil rights cases, they have a 12b6 motion. But he, number one, has wrongly asserted that, hey, because they didn't contest these in their motion to dismiss, it means I won. It means they're not contesting them, period. But the 12b6 isn't an answer. An answer is where you have to admit or deny. But let's think about it for a second. Okay? In his complaint, he says, they hit me in the nuts while I was in handcuffs. Now, we know that doesn't show up on the video. We fully disbelieve that. But for the purposes of a 12b6 motion to dismiss, the judge has to accept it as true that the officer hit him in the nuts. So, if the officer hit him in the nuts, basically, if an officer hit him in the nuts, a cause of action for battery or assault or whatever survives, because it's he's pled the absolute bare minimum, but it still would survive a 12b6. So Vegas didn't even attempt the 12b6 on that issue. But what they're going to do is they're going to deny it in the answer, and then they're going to move for summary judgment once they get the video on record, and the judge can consider the video as part of the evidence, as part of the record, and then they'll win. So, but here they're saying, even with the fairly low standards set out in Ashcroft versus Iqbal, he still falls far short of these basic pleading standards. And so, see, like I said, see Ashcroft versus Iqbal and the supplemental complaint, paragraphs 9 through 16, where he makes conclusory allegations against Google. The second supplemental complaint, paragraph 1, alleging that all defendants, including unknown ones, are responsible for unspecified infringements. If you don't even specify what the infringement is, you haven't pled anything. Plaintiff nowhere alleges that he registered any copyrighted work and concedes, as he must, that a copyright claim can be dismissed for not having alleged that the copyrights have been registered. This requires dismissal. Citing 17 U.S.C. section 411A, which is the copyright statute, and Fourth Estate Public Benefits Corp. Versus wallstreet.com from the Supreme Court in 2019. Plaintiff nonetheless seeks to avoid dismissal because Google has joined the party a bit late and other parties never raised the issue. Supposedly because plaintiff chose not to name Google as a defendant until his supplemental complaint, it is now too late to point out his failure to register any copyrighted works. I mean, in what world does that make any sense? Because no one raised this defense before Google was added to the case, even though Josh clearly did, because no one allegedly raised this before Google was added to the case, after the plaintiff chooses to add Google to the case, Google is barred from raising it by some mistaken interpretation of res judicata. That doesn't make sense. I mean, that would be such a violation of Google's due process rights if Kate and Josh's failure to allege it before Google is added to the case bars Google from raising it as their own defense. It's asinine. And Google says as much as my rant in a one-word sentence: nonsense. Google is raising the issue at its first opportunity in support of the motion to dismiss, citing Padula versus Freedom Mortgage Corporation from the District of Massachusetts in 2020, a Judge Burroughs case. Plaintiff's only other argument relies on a new fact not alleged in any complaint: that plaintiff has successfully and completely registered at least one key video. But an argument unsupported by factual allegations cannot prevent dismissal. When a plaintiff argues facts in opposition that are not alleged in the complaint, the court considers them only for the purpose of determining that it would be futile to allow plaintiff leave to amend his complaint. citing Azevedo versus U.S. Bank N.A. versus another Judge Burroughs case from 2016. Plaintiff's belated argument does not even justify allowing him leave to replead because he has only ever registered one video and did so after he instituted this civil action in violation of 17 USC section 411A. And they're citing the declaration of attorney Benjamin Margot and Exhibit A to his declaration, which is the copyright. And footnote 2, the court may take judicial notice of plaintiff's February 2nd, 2023 registration, which is viewable on a government website, authenticated by Benjamin Margot and not disputed. See Island Software and Computer Service versus Microsoft Corporation, Second Circuit, 2005. So basically they're saying, hey, even though it's not properly pled by the plaintiff, and even though they're basically authenticating it as a government record, that hey, for the purposes of this pleading, you can take notice of it. So plaintiff's failure to register any allegedly infringed work prior to bringing a lawsuit requires dismissal, citing Cortez Ramos versus Martin Morales, First Circuit 2020, and Fourth Estate from the Supreme Court, which said registration is akin to an administrative exhaustion requirement that the owner must satisfy before suing to enforce ownership rights. Plaintiff's failure to satisfy Section 411A renders futile any attempt to file an amended or supplemental complaint, citing Cortez Ramos. Allowing plaintiff, and remember, this is from the District of Puerto Rico, a collection. It says collecting cases. It's hey, judge, you can look at this case because it's got a whole bunch of citations so that I can just cite the one. But even though Delete Lawz does all the unpublished and persuasive or even not so persuasive out of district cases, he objects to this case. Allowing plaintiff to draw out this litigation would only validate his strategy of registering them one by one as needed. This would undermine Fourth Estate, Roblox Corp versus Wowie, which is from the Northern District of California in 2023, and make a meaningless formality out of Fourth Estate's requirement that the application be approved prior to filing suit, citing Malibu Media versus Doe from the Southern District of New York in 2019. See also My Larson Designs versus Want to Scrap from the Western District of Texas in 2019. Allowing plaintiff to sidestep Section 411A by filing amended or supplemental complaints would also be inconsistent with the text of the Copyright Act. As Judge Breyer held in a similar case, by tying the registration requirement to when a civil action is instituted, the plain language of Section 411A refers to the beginning of a lawsuit, not the filing of an amended pleading, citing Kiffel versus YouTube from the Northern District of California in 2021, which denied a pro se plaintiff leave to amend. And see also Hardwell versus Parker from the Central District of California in 2023. So, third argument. Plaintiff granted YouTube a broad license covering all works in suit. As noted, plaintiff does not dispute that he agreed to YouTube's terms of service, which states that by uploading his videos, he gave YouTube a worldwide, non-exclusive, royalty-free, sub-licensable, and transferable license to use that content, including to reproduce, distribute, prepare derivative works, display, and perform it in connection with the service and YouTube's business. Nor does he dispute that, under the plain language of the license, YouTube cannot be liable for directly infringing any copyrights associated with any content that plaintiff has uploaded to its channel, citing Business Casual Holdings versus YouTube from the SDNY in 2022, which is currently has an appeal docketed as of November 2022 in the Second Circuit. This is grounds for dismissal of plaintiff's claims, which are based on alleged infringement of videos that plaintiff himself had already uploaded to the YouTube service subject to the license. Plaintiff offers two make-weight arguments against dismissal on this ground. First, he claims the key video in this litigation was never published on YouTube and therefore is not subject to this license. But he leaves us guessing what the key video is. But plaintiff cannot save his claims by introducing a surprise unpublished video in his opposition brief and not even saying what that video is. In addition to being unalleged, this directly contradicts his existing allegations, which make clear that all works in suit were published as content to plaintiff's YouTube channel. The entire list of URLs is YouTube links. None of plaintiff's works are identified in any of his complaints except by YouTube URL. Second, plaintiff attempts to distract from the broad license he granted YouTube by instead quoting the license he granted to other YouTube users. Compare the motion at paragraph 5, where he quotes the license to YouTube, where Google quotes the license to YouTube, with the opposition at 4, where Delete Lawz quotes the license to other users. This is misleading. I bet it's intentionally misleading. The existence of another license does nothing to change the terms of the license to YouTube relied on by Google in its motion. Conclusion. Wherefore, Google respectfully asks the court to grant its motion and transfer the case pursuant to the forum selection clause, or dismiss the case without leave to amend. Dated June 14th, 2023, respectfully submitted by Google by its attorneys, Benjamin Margot and Matthew D. Gorman. And that was excellent, and it was served by ECF, and no meet and confer. Not that it matters, but so taking a peek onward, we have Benjamin Margot's declaration. I, Benjamin Margot, do state and declare as now that my computer's caught up to me, I, Benjamin Margot, do state and declare as follows. I am an attorney admitted pro hoc vice to practice in this court, appearing on behalf of Defendant Google LLC in the above captioned action, ECF numbers 120 and 122. I make this declaration based on personal knowledge. On June 13th, 2023, I searched the U.S. Copyright Office's publicly accessible database to determine if plaintiff Jose Maria de Castro has registered any copyrighted works, Specifically, I searched the official public catalog, 1978 to present, accessible at copyright.gov/public records. The search produces only one relevant result, a motion picture registered by Jose de Castro titled My Wrongful Arrest, registration number, with a date of creation listed as the year of 2015, a date of publication of December 19th, 2022, and a registration date of February 2nd, 2023. I saved an image of the relevant search result page, which accurately reflects the information displayed on the U.S. Copyright Office database. A true and correct copy is attached hereto as Exhibit A. I declare that under penalty of perjury that the foregoing is true and correct, and that this declaration was executed on June 14th, 2023 in Hudson County, New Jersey, signed Benjamin Margot. And then finally, we have Exhibit A, which is that screen capture of the copyright database. So that's where we stand for today in the Massachusetts case. That was concise, well so I think I disappeared for a second, but either way, I said that it was a concise, well-written motion, and I don't have a whole lot more to say about it because it was a concise, well-written motion and doesn't need much more explanation. So I have a feeling one way or another, Google's going to get a ruling in its favor, where I'm sure in the next couple days, like I said, going to get a frantic, histrionic laden request from Delete Lawz to file a SIR reply, which will be denied. And then he'll ask for oral arguments, even though they're not needed, but might be granted. And then Judge Burroughs can rule on this, and she can finally rule on the long outstanding motions to dismiss that Josh and Kate both filed way back in like January, that Judge Burroughs told them when she granted him leave to file an amendment. She said, I'm going to keep your motions to dismiss on file, and I'll let you know if you need to file a new one or amend it. She hasn't said that, so I'm guessing they're still good as far as she's concerned. So basically, that's where we are there. We'll see if we have more nonsense in Nevada by the time I wake up in the morning. But with that, I'm going to leave you guys there. Thanks for joining me for the third day in a row. Yikes. It's been a busy week, even busier for Delete Lawz. Do all the YouTube things, like, share, subscribe, and I will see you, I'm sure, much sooner than you want. So, bye-bye.